Imagine it's late on a Tuesday night. You're in your living room watching a movie when someone knocks on the door. You open it. 2 uniformed officers are standing there. They say something like, "We need to come inside. We've received some kind of report." You're stunned. You didn't call anyone. You haven't done anything wrong. They didn't show you a paper. And now you're asking yourself the question, this video is built to answer. Can they just walk in? This is a hypothetical scenario, but it's the kind of moment that plays out in real American homes every single day. And the answer is more complicated and more important than most people realize. Your home is the most protected place you have under the United States Constitution. The Fourth Amendment says that government agents cannot enter or search your house without a warrant, and without a good reason. That protection is strong, but it is not absolute. Over decades, courts have recognized a small number of carefully defined situations where police may enter without a warrant. Knowing those exceptions is what separates a free citizen from someone who quietly gives up rights they did not realize they had. By the end of this video, you will understand the default rule, every major exception that courts actually recognize, how those exceptions are frequently misunderstood, and most importantly, what you can practically do to protect yourself if an officer ever shows up at your door. Let's start with the foundation, because everything else rests on it. The starting point is simple. Under the federal Constitution, police need a warrant to enter your home. That principle was confirmed in the 1980 Supreme Court decision Payton v. New York. The court made clear that the physical entry of a house is the chief evil against which the Fourth Amendment is directed. Without a warrant, an in-home arrest is presumptively unreasonable, and a warrantless search is presumptively unreasonable too. That default is consistent across the country. Federal courts apply it. State courts apply it. And the practical takeaway is straightforward. If an officer shows up without a warrant and does not fit into one of the narrow exceptions that courts have carved out, they have no business being inside your home. Knowing those exceptions is the entire reason this video exists. So let's walk through them one at a time in plain English. The first scenario, and probably the most common, is consent. If a person who lives in the home voluntarily agrees to let the police in, the officers can come inside lawfully and even conduct a search, all without a warrant. But here is where it gets tricky, and this is the detail most people completely miss. Consent has to come from someone who actually has authority over the space. In most cases, that means the homeowner, the leaseholder, or another person who lives there. A house guest generally cannot give the police permission to search the host's bedroom. A visitor cannot give a blanket. Go ahead. Authority matters. The law also cares about whether the consent is real. The Supreme Court has long required that consent be voluntary, not the product of coercion. Police are not supposed to bully, threaten, or pressure you into saying yes. If they do, the consent can later be challenged. Here's a situation that comes up more than people might think. Imagine 2 roommates share an apartment. One roommate is standing at the door. The police ask to come in. That roommate says, "Sure." Oh, the other roommate is right there, in the next room, clearly objecting. Does that door open? Under the 2006 Supreme Court decision, Georgia v. Randolph, no. When 2 occupants are present and one objects to the search, the consent of the other occupant is not valid. The objecting occupant's refusal controls. This is one of the strongest protections a roommate, a spouse, or a cohabitant has when police show up uninvited. Now, there is a wrinkle. The court has also said that consent can be valid when an officer reasonably believes that the person giving consent has authority, even if that turns out later not to be true. This is the apparent authority rule from Illinois v. Rodriguez in 1990. So, if a person says they live there, behaves like they live there, and the officer reasonably concludes they do, the entry can still be lawful. But reasonable belief is the standard. Honest misunderstanding by the officer matters. Made up or manufactured belief does not. One more important detail. You have the right to say no. Saying no to the police, when you are the person with authority over the home, is not a crime. It is not obstruction. It is not suspicious. It is the exercise of a constitutional right. If you do not want officers inside, you can simply say, "I do not consent to a search." Saying it out loud, clearly, creates a record. That single sentence has protected people's rights in courtrooms for generations. Now let's move to the second exception. And this one causes more confusion than any other. It is the emergency aid doctrine, sometimes called the community caretaking exception. You've probably heard someone say, the police can enter your home if they think someone is in danger. That is broadly true. But it is also the rule that is most often stretched and most often misunderstood. The Supreme Court addressed this directly in Brigham City v. Stuart in 2006. Officers responded to a noise complaint, looked through a window, and saw a fight with a juvenile who appeared to be in need of medical attention. They entered. The court ruled that, in an emergency situation, officers do not need a warrant to enter a home. The standard is whether there is an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with serious injury. Notice the word reasonable. It does not mean we had a hunch. It does not mean we thought something seemed off. It means an outside observer, looking at the same facts, would conclude that immediate action was needed to protect someone inside. The court also clarified this further in Michigan v. Fisher in 2009. That case reaffirmed that officers responding to an emergency do not need probable cause in the same way investigators do when gathering evidence of a crime. They need an objectively reasonable belief that aid is required. That is a lower bar than probable cause, but it is not zero. A vague tip, a feeling, or a wild guess is not enough. Now here's the mistake that the public and even many officers still make. The community caretaking idea has limits, and the Supreme Court drew a hard line in 2021. In Caniglia v. Strom, police entered a man's home after a domestic dispute. They persuaded him to go to a hospital for a mental health evaluation, then entered his house to seize his firearms without a warrant, claiming they were acting in a caretaking role. The Supreme Court unanimously rejected that move. The court made clear that the community caretaking function that allows officers to approach and help citizens in public does not automatically extend to entering a private home without a warrant. In other words, the exception is real, but it has a ceiling. Officers cannot invent an emergency to justify walking through your front door. So now you might be thinking, what about police chasing a suspect? That brings us to the third major exception, and it is where the rule has actually changed in recent years. For decades, courts allowed officers pursuing someone they had probable cause to arrest for a serious crime to follow that person into a home if the pursuit was immediate. This is the hot pursuit doctrine, and it traces back to older Supreme Court cases involving felony arrests. The classic example is a suspect fleeing a robbery who runs into their own home. Officers in immediate pursuit can legally follow them inside. But in 2021, the Supreme Court decided Lange v. California. The court ruled that pursuit of someone suspected of a misdemeanor, like a minor traffic offense, does not automatically justify a warrantless entry into the home. Officers still need to assess the specific circumstances. Is there really a risk of escape? Is there reason to think evidence will be destroyed? Is there a threat to public safety? If none of those are present, hot pursuit alone does not get them through the door. This matters because before Lange, many officers assumed that any suspect fleeing into a home was fair game. That assumption is no longer correct. The same case-by-case analysis applies regardless of the offense. Closely related to hot pursuit is the broader exigent circumstances exception. Exigent circumstances exist when there's a genuine emergency that makes getting a warrant impractical. Common examples include active threats to life, the imminent destruction of evidence, or the hot pursuit of a serious suspect that we just discussed. There are two crucial limitations worth remembering. First, the emergency must actually exist. Courts do not accept manufactured emergencies. If the police themselves created the urgency through their own unlawful conduct, the exigency falls apart. For example, if officers bang on the door loudly enough that the residents start flushing evidence down the toilet and then claim exigent circumstances to enter, courts have rejected that argument. The doctrine requires a real pre-existing emergency, not one cooked up by police action. Second, exigent circumstances only justifies the entry that is reasonably necessary to deal with the emergency. Once officers are inside and the emergency is resolved, the exception ends. It does not automatically convert into permission to search every drawer, closet, and phone. This brings us to the fourth exception, plain view. The plain view doctrine is one of the most straightforward rules in constitutional law. If an officer is lawfully present in a place, and an item that is obviously evidence of a crime is sitting out in the open, the officer can seize that item without a warrant. 3 requirements must all be met. The officer must be lawfully in the location where the item is seen. They cannot enter your home illegally and then claim plain view. The officer must have probable cause to believe the item is evidence of a crime, contraband, or otherwise subject to seizure. Notice that an item being visible is not enough. If a cop walks past a locked gun safe and sees a gun through the glass, that's plain view. If that same cop walks past your medicine cabinet and sees a prescription bottle, that probably does not justify seizing it without more. The officer must have a lawful right of access to the item. If the item is inside a closed drawer, in a closed container, or in another locked space, plain view does not authorize opening it. That would be a separate search, requiring a warrant, consent, or another recognized exception. Plain view is the reason police who lawfully enter your home for emergency aid or under consent can pick up obvious evidence in plain sight, but cannot open drawers to look for evidence they did not already see. The fifth exception is narrower, but it comes up any time officers make an arrest inside a home. It is the protective sweep doctrine from Maryland v. Boyd, decided in 1990. The court held that when officers make a lawful in-home arrest, they may also conduct a limited protective sweep of the premises. A protective sweep is a quick, limited look in spaces where another person could be hiding, such as closets or behind doors. The sweep must be based on a reasonable belief that the area poses a danger to officer safety, or contains another person who could threaten those on scene. Two limits matter here. The sweep is supposed to be quick. Officers are not allowed to linger or rummage. The sweep is supposed to be limited to places where a person could physically hide. Officers may not open drawers, lift boxes, or check containers. They may look, but they may not browse. If the officers have additional, specific facts suggesting that a dangerous person might be in a particular area beyond the immediate location of arrest, they may extend the sweep to those areas. That extension is allowed under the same decision, but reasonable belief is again the standard. Generalized worry about safety is not enough. Officers need articulable facts. Now that you understand the 5 major exceptions, let's talk about the moment most people get confused about. The knock at the front door. When officers have a warrant, they still have to comply with the knock and announce rule. The Supreme Court addressed this in Wilson v. Arkansas in 1995. Officers are generally expected to knock, identify themselves, and wait a reasonable amount of time before forcing entry. The rule exists to give occupants a chance to open the door peacefully, to reduce surprise, and to protect innocent residents who may not immediately realize police are there. But here is the nuance. The court has also recognized that knock and announce is not absolute. In some situations, such as when officers reasonably believe that knocking would give a suspect time to destroy evidence or pose a danger, exceptions apply. And in many real cases, courts have carved out practical allowances when, for example, officers announce themselves but forced entry very quickly afterward. What does this mean for you? It means that if police knock, identify themselves, and you have no idea whether they have a warrant or whether an exception applies, you should not swing the door open wide. Simply ask calmly, through a closed or partly open door, "Do you have a warrant?" That one question often clears up the situation immediately. If they say yes, ask to see it before granting entry. If they say no, you have just prompted them to articulate which exception they believe applies. Either way, you have created a record. Let's put this all together with a few practical scenarios that are common and entirely hypothetical. Scenario 1. Police knock at a noise complaint, and through the window they observe a resident unconscious on the floor with bleeding. That is the textbook emergency aid situation. Officers can enter under Brigham City v. Stuart without a warrant. They are responding to what appears to be a serious medical emergency visible from outside. Scenario 2. Police receive a call from a neighbor saying there's a loud argument inside a home. They arrive, knock, and a resident calmly says, "Everything is fine, please leave." Officers hear no sounds of distress, no calls for help, no sounds of struggle. They cannot enter. There is no emergency. There is no consent. There is no warrant. They must leave. Scenario 3. Police arrive with a warrant that has a minor clerical error in the address. The warrant is otherwise proper, signed by a judge, and supported by probable cause. Many officers would still enter. In some cases, courts have upheld such entries if the error was reasonable and not misleading. In other cases, they have not. Warrant defects are a real issue, but they are highly fact-specific, and not something a resident can determine on the spot quickly. When in doubt, ask to see the warrant. Scenario 4. Police show up with no warrant and ask to just look around. They are friendly. They say it will only take a moment. They say if you have nothing to hide, you have nothing to fear. This is the moment where many Americans give up rights they could have kept. The Constitution does not give the government the right to search your home just because you are friendly, or just because you have nothing to hide. You can politely decline. "I do not consent to a search" is a complete answer. It is also one of the most powerful sentences in American constitutional law. Now, some practical takeaways worth keeping in your back pocket for life. First, the home receives the strongest protection of any location under the Fourth Amendment. The bar for the government to enter it is the highest of any place you can be. That protection extends to apartments, to rooms you rent, and to any space you lawfully occupy. Second, the exceptions are real, but they are narrow. They include consent, emergency aid, exigent circumstances like hot pursuit, plain view, and protective sweeps during in-home arrest. They do not include the officer had a hunch, the officer thought something seemed off, or the officer wanted to help. The Supreme Court drew a clear line in Caniglia v. Strom that community caretaking does not, by itself, justify entering a home. Third, you can always ask one simple question. Do you have a warrant? Asking that question is never a crime. It is the single most useful sentence in this entire video. If they produce a warrant, ask to read it. If they do not, ask them why they believe an exception applies. Either way, you have created a verbal record. Fourth, if you choose to refuse entry, do so calmly, clearly, and without physical resistance. State your refusal, then close the door. Do not push officers. Do not block them. Do not pursue them. If an officer decides to enter anyway, do not physically interfere. That part's become a different legal question, and interfering with police, even when you believe the entry is unlawful, creates serious legal risk for you. Let a court sort it out later. Fifth, Laws vary by state. Federal constitutional standards set the floor. Many states have additional protections written into their own constitutions or statutes. In some states, officers need more than the federal baseline to enter without a warrant. If you want to understand what applies in your specific state, look for official guidance from your state attorney general, your state court system, or a licensed attorney in your jurisdiction. Do not rely on social media posts, viral videos, or anonymous online forums for legal advice about your own rights. Summing it up, your home is your strongest constitutional space. Police normally need a warrant. The exceptions are consent from someone with authority, an objectively reasonable belief that someone inside needs emergency aid, exigent circumstances such as genuine hot pursuit, the plain view observation of obvious criminal evidence, and limited protective sweeps during a lawful in-home arrest. The community caretaking function does not grant a free pass. Hot pursuit for a misdemeanor does not automatically open the door. Manufactured emergencies do not count. And manufactured consent, consent that is not truly voluntary, or consent from someone who lacks authority, is invalid. If you carry this knowledge forward, you will be better prepared than the vast majority of people in this country. Most Americans never learn this. Most never understand what counts as an exception. Most answer the door, cooperate, and never realize they gave up a protection the Constitution specifically gave them. You do not have to be that person. Hold on to one sentence whenever this situation ever comes up for real. Ask, do you have a warrant? Then decide what to do with the answer.